It's not unusual for some jobs in Ontario to involve sending employees home earlier than they expected to work, such as situations where a grocery store schedules more cashiers than necessary on a particularly slow day, or an amusement park that staffs too many ticket counters when very few guests show up that day. Both employees and employers might wonder what happens to an employee's wages when the employee gets sent home early, but they had made themselves available to work longer based on their usual schedule. Let's talk about what Ontario's Employment Standards Act has to say about this. However, before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. My name is Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. The ESA has something called the 3-hour rule, and it is found within Part 7.1 at Section 21.2. I'm going to display the wording of Section 21.2 on the screen now. You're welcome to pause the video, and when you're ready, I'm going to use some simple examples so you can get a better idea of how this law would play out in the real world. Okay, let's keep a few things in mind. In order for this section to apply, 3 conditions must be fulfilled. First, the employee typically works more than 3 hours daily. The rule does not apply if the employee's typical workday is 3 hours or less. Second, the employee must report to work as scheduled. This section is not applicable if the employee reports to work contrary to the employer's instructions, even on a normal workday. Third, the employee works less than 3 hours, although they are ready and able to work longer. This clause specifies that for Section 21.2 to be applicable to the situation, the employee must be willing to work beyond 3 hours. Hence, if an employee leaves work early, perhaps due to illness or prearranged leave, they cannot claim wages for 3 hours under this provision. Furthermore, the rule's application is not limited to regular work days. It can also apply on days the employee doesn't usually work, provided they were scheduled to work on that day. If an employee's routine includes both days with more than 3 hours of work and days with 3 hours or less, the applicability of the rule hinges on the nature of the particular day in question. For instance, if employees typically work 8-hour days from Monday to Friday but are occasionally scheduled for Saturday morning meetings, the 3-hour rule would apply to these Saturday meetings. However, if 1-hour Saturday meetings become a regular schedule, the rule would not apply, as the law doesn't aim to restrict employers from having regular schedules with shifts shorter than 3 hours. Another example could be a schedule where an employee works 4-hour shifts on Mondays, Wednesdays, and Fridays, and 2-hour shifts on Tuesdays and Thursdays. The 2-hour shifts on Tuesdays and Thursdays wouldn't activate the 3-hour rule, as the employee regularly works less than 3 hours on those days. Yet, if the employee receives less than 3 hours of work on a Monday, Wednesday, or Friday, the rule would be applicable. All right, let's head over to those examples I mentioned earlier. Consider the case of Emily, an employee who normally works more than 3 hours a day. Emily's regular hourly wage is $28. One day, Emily works for only 1 hour and is then asked by her employer to leave. For this 1 hour of work, Emily is paid her regular rate of $28. Under subsection 1 of Section 21.2, Emily's pay entitlement is calculated in 2 ways. The first way is by adding her earnings for the 1 hour she worked, plus the remaining 2 hours of time to meet the 3-hour rule, totaling $84. The second way to calculate this is by ignoring how much time she worked and just calculating 3 full hours of work, which also amounts to $84. In this instance, Emily is entitled to $84. You might be wondering, at this point, why there are even 2 calculation methods described in the ESA, and why the section uses the phrase "the greater of" to make it clear that the employer has to pay whichever calculation method gives Emily more money. In the example we used, both calculation methods equal the same number, and it's tempting to think that this will always be the case. If I'm being honest, I was a little bit confused by this as well when I read the law for the first time. But let's use another example to clarify this point. Let's modify Emily's scenario a bit. Suppose Emily earns overtime pay at 1.5 times her regular rate for the 1 hour she worked. This means she earns $42 for that hour. In this case, Emily's entitlement is calculated as either the sum of her overtime earnings plus 2 more hours at her regular hourly rate, totaling $98. Or, based on calculation method number 2, just her regular rate of pay for 3 hours of work, which would only be $84. According to subsection 1 of Section 21.2, Emily is entitled to the greater amount, which in this example is $98. This makes sense if we consider the possibility that Emily worked a particularly large number of hours that week, which caused her to already be in her overtime hours right from the moment her shift started that day. It's important to keep in mind that there are some exceptions to the 3-hour rule. According to subsection 2 of Section 21.2 if the employer is unable to provide work due to unforeseen circumstances beyond their control, such as power failures or severe weather. This obligation does not apply. Also, like I mentioned earlier, I have another video about types of jobs where the ESA doesn't apply. I'll repeat some of the information from that video now. Just keep in mind that what I'm repeating here is not going to include a complete list. I strongly recommend watching my video entitled "Does Ontario's Employment Standards Act Apply to Your Job?" if you want to see a much longer list of jobs that are excluded from this rule. Like I mentioned earlier in this video, the 3-hour rule lives in Part 7.1 of the ESA, so that's the part number you want to look out for when you hop over to the other video. All right, so according to Section 4.1 of Ontario Regulation 285/01, the following types of employees do not get to enjoy the 3-hour rule. First, students working in recreational programs run by registered charities, as long as their work is directly related to the program. Second, students employed to teach or supervise children. Third, students working at children's camps. And lastly, fourth, anyone working as superintendents, janitors, or caretakers of residential buildings who live in those buildings. By the way, any students who are employed as wilderness guides will be happy to know that you still get to receive the benefit of the 3-hour rule, because even if your job falls into the first, second, or third types of jobs that I mentioned in that list, you still have the protection of Section 21.2 if you are employed as a wilderness guide. Thanks for watching today's video about the 3-hour rule in Ontario. I'm Ryan Keeney, and it was great sharing these insights with you. If you found this video useful, please hit that like button, remember to subscribe, and click the notification bell to stay updated on our latest content. Your thoughts and questions are valuable, so feel free to drop them in the comments section below. Remember, staying informed about your workplace rights is crucial. Until our next video, take care and see you soon.